Hello, YouTube. So I'm going to drop in, make a quick video on trademark, and specifically the issue of priority. Um, I think most people kind of have a general idea of what a trademark is. And the federal statute on, which would be the Lanham Act, on what a trademark is. Trademark is a distinctive mark in commerce that basically alerts the consumer product that they're searching for. So the whole purpose of a trademark is to ensure that the individual consumer is not misled in trying to purchase the products that they think they're purchasing. Um, it does not depend on novelty. It does not depend on invention. It does not depend on discovery or any other um, creative work of your mind. It's simply a distinctive mark that's used in the marketplace to alert the consumer to the goods that you've produced, or in some instances to the services that you provide. Trademarks would also include things like uh, trade names, so a specific business name that you operate under, as well as certification marks. The best certification mark that I can think of is UL, right? UL, you'll see that mark on almost every electronic product. Um, and that's a certifying agency that basically certifies that that product's a safe electrical device. So that would be a certification mark. You need, again, a trademark to alert the individual consumer to the product or the service that you're selling in the marketplace. The whole goal behind trademark is to eliminate confusion in the marketplace with counterfeit goods. And anybody who has taken their child in to go shopping, and I'm going to point out the cereal aisle. If you've had a child walking through the cereal aisle, you understand the importance of trademark, right? Getting the wrong cereal obviously is detrimental to the child, right? They've got a particular cereal in mind. They don't want the knockoff. They want the brand name, and so the brand name is the trademark, right? That's um, the mark that's going to alert you that, okay, these are Cocoa Puffs, not Cocoa Poofs, right? So it's important in that sense. And I like to draw that example because it's an easy one for people to think about. I think most people, certainly most parents, have been in that situation, and the importance of making sure that you have good trademarks to alert you to those goods. So the rights that a trademark confers really depends on the use and the geographic scope of the use. So at common law, and common law is just a fancy term for non-statutory case law, but at common law, so before the Federal Trademark Act, which is the Lanham Act, prior to that, trademark was really about the goodwill that the owner of the mark had developed within a specific geographic area. So I'm here in Washington. So if I had, developed a business and I sold products here in Washington, let's say maybe Oregon, Idaho, and Montana as well, then under the common law, if I had established goodwill in those areas within that market, I have a trademark, right? I've established the trademark. There's no special filing requirements that I need to go through in order to assert an infringement case or an interference against an individual that's using that same mark to sell similar goods. This is important in that geographic area. That's very limiting if you think about that. So if I had another individual who was using that same mark in that geographic area, but let's say I was selling cupcakes and he was selling lawnmowers, right? The likelihood that there would be confusion there is non-existent. You're not going to have people going out looking for cupcakes that mistakenly purchase a lawnmower. In fact, they're probably not located in the same stores. The other thing is the geographic scope, right? If the scope is different. So in my example, previous Washington, Oregon, Idaho, Montana, that's where my trademark is protected. But if I had an individual using the same mark in California, Utah, Nevada, Arizona, and Colorado, which is very close, but not the same geographic scope, different scope, even if they had the same mark and were using or selling identical products, cupcakes in my example, I wouldn't be able to assert a claim against them that they've somehow trampled on my goodwill as a trademark owner. Okay. So this gets to the idea of registration. Registration for trademarks is through the Patent Trademark Office. And registration is something that I think any business owner that, or certainly any brand owner that has a trademark, needs to consider. Now, I think most businesses, the goal of that business is to scale the business, grow the business. And despite the fact that you might currently be in a regional market, you would want to prevent the possibility that you would foreclose your market. And so if you're in a regional market like the Northwest, but you had goals of expanding to a national scale, right? It's important that you consider registration because there's this idea of priority, right? If somebody beats you to the Patent and Trademark Office, that let's say they're in the Southeast region, right around Florida, and they're using the same mark, same product, cupcakes, and obviously they're ambitious and they want to scale that business just like you do, but they beat you to the trademark office and they actually register. That's going to create problems for you. Now, you're probably still going to have some protection within your regional market from which you had established yourself. However, it's going to prevent you from growing beyond that and using that mark because the individual down in the Southeast had beat you to the punch. And so it's really important that even if you have what you would say is a small business, a regional business, if you have aspirations of growing that business, it's important to consider registration through the Patent and Trademark Office. And I do registrations. There's plenty of attorneys throughout the country that do registrations. And so I would encourage you, if you are in that type of a situation, to reach out to an attorney, discuss that with them, and see whether or not registration is really a smart idea for you. Don't foreclose that option just because you think that your business is too small at that point to make that investment. Now, with respect to priority, it needs to be shown when you register that you actually use that mark in commerce. Okay, it's not enough. Well, you can register under the auspices that you have a goodwill or bona fide intention to use that mark to sell either products or services in the market. However, this is one of the more common reasons that trademarks are actually denied at the PTO office, is the fact that you actually are not using it in commerce. So it's important, I think, to make sure that you're actually using that mark. It's not absolutely required, but it does give the Patent and Trademark Office a reason to deny your application if they think for some reason that you're not, quote, bona fide in your intent to actually use that mark, and that what you're really doing is acting like a patent and trademark troll. This is a term in the legal field where individuals will go and they'll get these registrations either for trademarks, or you see it a lot in patents. And then once they've locked that down, then they'll market that as a product themselves, right? That is a frowned upon practice. So if there's any sense from the Patent and Trademark Office that is what you're engaging in, they're likely to deny it. If you clearly are using that product and you meet the other requirements of filing, you're likely to get that trademark approved. If you have any questions, you're welcome to contact me at briggslawplc.com. And I wish you all the best in your business ventures and in your trademark registration process. God bless.